All right, good afternoon. I think we're going to go ahead and get started. Thank you, everyone, for coming to this month's Hot Talk. We are focusing on Justice Center issues for the next few months. This month, we are doing bail and bond reform in Cleveland Municipal Court. So today, we have Judge Pope-Earley from the Cleveland Municipal Court. We also have Stephanie Pope-Earley, who is the director. Help me with that, Stephanie.
Pretrial services for
of pretrial services for Cleveland Municipal Court. And Judge Ray Hedden, he serves on our thought leadership committee that helps put together these hot talks every month, and he will be moderating the conversation today. So Judge Hedden, I will kick it off to you.
Well, thank you so very much. It is indeed a pleasure and an honor to participate in this panel. This panel is extremely important. Is a judge of the 8th District Court of Appeals here in Cuyahoga County. One of the things that I am most interested in is what's going on, particularly in the Cleveland Municipal Courts, because that's usually the first touch of any type of access to the criminal justice system for anyone, and particularly our youth. What we need to be able to do is to be able to stop before it gets started, the pathway towards mass incarceration and all the things that we deal with as appellate judges regularly, from misdemeanors to felonies. So bail reform, bond reform, it is important because in essence it allows for us to be touching and changing the pathway of people's lives. So I'm extremely interested in this myself, and right now I'm pleased to introduce our panel. Our panel is comprised of Judge Pope-Earley. Judge Earley was appointed to the Cleveland Municipal Court on April 20th, 2009, and was elected the following November. And then by unanimous vote of the judges in December of 2017, she became administrative and presiding judge, making her responsible for the business and overall direction of the court. Welcome, Judge Earley.
Good afternoon.
Yeah, and in addition, as already mentioned, we do have the Director of Pretrial Services, and this is Stephanie Pope-Earley. No relation.
Great last name.
It's a great last name, exactly. Well, one of the things that's most important is that, and we'll probably get into it first with Judge Earley's comments, is that as Director of Pretrial Services, this was the first new department for the Cleveland Municipal Court in over 23 years, showing the importance of the leadership there of municipal judges in Cleveland. All right, ladies.
And I'll start. Good afternoon. I just came from a criminal justice council meeting, and in that meeting we had some individuals who were there who talked about the trauma of going to jail and about money-making determining factors regarding who's released and who's not, and how unjust that is, and how unjust it is to have a system that is based on that, that's not looking at those determinations. In Cleveland Municipal Court, and I speak on behalf of all of the Cleveland Municipal Court judges who, I can undoubtedly say that all came to the court, the Cleveland Municipal Court, to make a difference. Who was interested in not just handing out sentences, but in changing the lives of the people who come before the court. I think that's reflected from the different programs that we have and the specialized dockets, that the judges are really adamant and passionate about change and about justice. When the bail reform recommendations came out in early 2018, the Cleveland Municipal Court, a number of those things we were already doing. And some of the examples of that, there was a recommendation that bail hearings be had 6 to 7 days a week. We have court Monday through Saturday. The judges come in on Saturday, and we have bond determinations for everyone who is arrested. We have individual bail determinations within 48 hours of arrest. That was one of the recommendations, and that was something that the Cleveland Municipal Court has been doing for a number of years. The ability to accept bail payments 24 hours a day, 7 days a week through Clerk of Courts Earl Turner. That is something that's been in place for a number of years in Cleveland. and defense lawyers being present at bail hearings. So when the recommendations came out in 2018, the Cleveland Municipal Court had already done a number of those things before they even were reported. After the report, and actually maybe not, we had already been doing it after the report, but a fairly, within the last couple of years, change for the Cleveland Municipal Court is that we made a decision as a court to allow the presumptive release of nonviolent offenders. So if someone, or for nonviolent offenses, so if someone is being arrested for a driving case, or really anything that's not an offense of violence, a domestic violence case, those people are being released on a personal bond upon arrest. So that is something that we have collectively done, and we eliminated the use of the bond schedule. So instead, if it's a violent offense, they come to arraignment within that 48 hours or earlier, or they're released on a personal bond. From there, and under the direction, that was under the direction of Judge Adrian, who was the administrative and presiding judge prior to me, who was, I'm giving a shout out to Judge Adrian, who was really innovative and kind of forward-thinking regarding some of these ideas, and I actually happened to be able to come behind him and like jump onto the momentum and keep it going. But he was really the person who kind of put the train in motion and kind of did the, starting up things, which is not always easy. Under the direction of Judge Adrian, we did the risk assessment for all of the cases that came in arraignment, and that's for the misdemeanor cases and the felony cases for the people who are arrested in the city of Cleveland. We partnership with the Arnold Foundation to do a risk assessment for all of the cases. The significance of that, and the interesting thing is, when you have a lot of judges and you have a lot of opinions and way of doing things, it's kind of hard to get everyone on the same page and to get buy-in for things. And I think we just had a lot of conversations, a lot of input from the judges, so that when the time came for us to go forward regarding the risk assessment, there was enough discussion that we were comfortable moving forward. The purpose of the risk assessment was to be able to make determinations regarding bond that were not based on someone's inability to pay or some random criteria that may have a negative effect on a certain population. And an example of that would be, on its face, it appears to be a good bond determination about whether or not someone has a job. If you have a job, they get released. But if there's a certain population or a certain community that has a high unemployment rate, then the effects of that bond decision is going to negatively affect a certain member of the community. Another example is if you're making a bond determination on education. Did you get a high school degree? Did you get a diploma? And there is a significant portion of the community that we represent that does not have a diploma, that did not graduate. Then the determination regarding bond has a negative effect on that person because of where they grew up. That doesn't have anything to do with risk or failure to appear. And that's not fair. But on its face, it doesn't appear to be something that is done in a manner that's intended to discriminate against anyone. So being able to have those conversations, because those are not easy conversations to have, because the intention is not to be discriminatory towards anyone when you're making those determinations. And it seems to be a blanket criteria that you can use across the board in terms of making a proper decision. And that's kind of why we were, those were difficult conversations to have. But when we were able to use the Arnold Foundation and we got criteria that was based on, what's the failure to appear rate in the past? And how does that then reflect on whether or not they're going to appear currently? What's the criminal activity rate in the past? And what's the pending charge in the past? And to get us to look at some consistent factors that we can then use to set bond determinations. Are they always correct? No. That's why you have the judge. That's why we're here, to make that determination. Because there are some cases where the risk on its face may be very low, but is a very violent offense. So as a judge, you have to make that correction. But there's also certain circumstances where the current offense in front of you is if it's a felony, it's a nonviolent offense and it's coming before the court, even though the risk is high, you also have to weigh that in accordance with the type of case that's coming in front of you and make that determination. And we've been able to do that, but the risk assessment has allowed us to collect information consistently and make those determinations. Part of what we were seeing when we were doing the risk assessment was there is a group of people. It's easy when you're, and it's not, bond reform is not easy, so I don't want to use that word, but it's not as difficult when you have someone whose risk level is low and the risk level is high, because you pretty much know what to do with them. We were having difficulty in the people who fell in the middle and what you did with that group of people. That's when we started putting together our pretrial services department. Part of what the pretrial services department was intended to do, and we believe is doing for the court, is allowing us to allow people to be released under GPS monitoring. So if in fact the only risk factor in terms of new criminal activity is going to be against the alleged victim in the case, we can put a GPS monitor on that person to ensure that that person would, again, none of this is 100% fail-safe, but to make it so that there is a less risk that this person will cause further harm to that individual. And people who have possibly not been so consistent in showing up in the past, having them meet with a pretrial service officer who is reminding them of their court dates and reminding them of having to come to court was important in our process. We have handouts that I think we left at the back in terms of what we have experienced regarding the success rate of that and bringing failure to appear rate. We were over 40%, and now we're
8%.
That's why I brought her. She's going to get into all the numbers. We're down to 19%. That's significant. That's significant to the person who gets to be released, but it's also significant in terms of the justice. So if, in fact, someone has been a victim of a case, that person is coming to court, so that we're able to address that issue so that the alleged victims in the case get justice as well. That's also really important. In addition to that, in our pretrial services department, if in fact the judge who is hearing the case decides, this is not a case I'm necessarily going to do pretrial services with, so you're going to stay in jail, the judge that's assigned to that case, that next court date, we get a bond review. So we get pretrial services will provide to the judge who now is assigned to that case a review of that case that lists the risk assessment, the original recommendation, whether or not that person has any holds. Now, they don't give us the information that we're not supposed to have in terms of deciding the case, which would be criminal history and those things. We don't have that information, but we do have the information that would allow the judge now who is hearing the case to then make that determination. And the majority of our judges, when someone is arraigned, if in fact they're not released, within 2 to 3 days, they're in front of the judge that's assigned to that case. We had a lot of discussion regarding pretrial services amongst a court. Initially, some judges were like, well, we're just doing misdemeanors, should we be doing this? Should we be spending this resource? And how do you get 12 people who may have different avenues of how this works to buy in? And I tell you, we sat down and we had conversations about it. And we talked about what was important for us as a court, what we wanted to see happen, basically why we were here, and then we mapped it out. And the reason why we did it that way, as opposed to, could we have done it another way, just say, okay, we're going to put it all together and then, judge, you can use this. The way we did it in terms of buy-in, when we started it, then the judges had already bought in and they were willing to use it. And that was important because it wasn't going to make an impact if only 2 or 3 of the judges utilized it. Again, obviously we have our own discretion in how we're utilizing the tool, but the majority of the judges utilize the pretrial services tool. We also have, and I'm going to, the Oriana House is actually here with us today, and they've played a big part in being able to allow us to do this pretrial services portion. They do the supervision and the GPS monitoring for us. They have been wonderful partners in allowing us to have a person who is assigned to the court and who stays with at the court all day. And what the significance of that is, when somebody posts your bond at 2 o'clock and you need a GPS monitor, you don't have to spend the night in jail because the person who's going to give you the GPS monitor is not there. And they have said to us that they believe that that's important, that when someone posts a bond, they need to be released with that GPS monitor because it's something that, we've committed to do. In Cleveland, we do not have, the defendants do not pay for the GPS monitor. And that, again, I'm just commenting about what we're doing. The significance of that is for the Cleveland judges, and again, I'm just speaking about what we're doing. If you have to pay for your GPS monitor, we're right back at the same place that if you have money, you get to be released, and if you don't, you have to stay in jail. And for us, that was not what our pretrial services or our bond reform looked like. Now, there may be, and again, we were very lucky that we were able to speak with the Frank Jackson administration and get funding for the pretrial services. It was not free. We had to request funding to get, because somebody has to pay for the GPS monitoring and somebody has to pay for the services. And we were able to show the administration in terms of getting our budget that if we invested in the front end to get people on pretrial services and to kind of direct them, that we'd save money and human cost, because as members of the community, that is important to us. We save money, we save human costs, but we also save jail costs, because you save money by releasing people, even if it's on GPS, then you do housing them. But in addition to that, even a couple of days in jail can ruin somebody's life. And then when you have them then come to court and you're talking about, in Cleveland, which we strongly believe in, putting lives back together, it's difficult to do when you've already lost your job and your housing and a number of other things because you had to sit in jail a couple of days. And even to the fact of maybe sitting in jail more before you've been convicted of what the judge would have given you afterwards, that to us did not look like justice. Again, that's kind of what we did with a big overview. We actually were really lucky in Cleveland. We had, when it came time so the judges had this concept, and we got a lot of work to do, so we couldn't, again, we're just way up here with the concept. So we said we needed somebody who had our passion and who understood our vision and could put this together as if we were sitting there doing it ourselves. So we put out a job request to, we created a new department. There's no employees there, this new department and this lofty idea from the judges. So again, we're way up here, right? We want you to change the world. That's what. So you put out a request, and we get these people coming in for interviews, and we get Director Pope-Earley, and she has a wonderful last name, but that's not why we hired her, who had been with the court for 18 years and had 18 currently, but probably 16 then. Had displayed a passion, and she was in the probation department, had displayed a passion not just for the what we were doing with the court, but from her activities in the community, of the different things, the board she was on, the different community activities that she was a part of. And you don't always get somebody who's actually in-house who has the same passion as you do to kind of say, listen, we got these goals up here. We didn't tell her that part. We said the goals were here, but they were really right here. And we were saying, listen, we need you to come and do this. And she was willing to do that. So she was tasked with starting the department, hiring the employees, putting the policies in place, and then she has 12 judges looking over her shoulder like, is that a comma? Kind of did that, but and the success we have is really based on the work that they've done. They've made us look phenomenal. And, again, we came up with a concept, and they were able to put it together and make it work. And then, again, you have 12 different judges, 12 different, ideologies, and being able to, work with all of us consistently, is nothing short of a miracle. So I'll allow her to give you some of the details and kind of go over some of the things that I talked with you about how they kind of assist us in doing, what we do. The only other thing I will say in terms of the lawyers who appear in Cleveland Municipal Court, and you have a risk assessment that, you're looking at your risk assessment, you're like, my client has a 6 out of 6. The judge is probably going to give them an extremely high bond. Again, as I previously stated, we understand the basis behind that. If it's going to be a high risk, we understand that. If it's the fact that your client has an issue coming to court regularly, we may put some things in place, but it's not necessarily an automatic thing. So the risk assessment is used as a tool. It's a helpful tool. It shows you up front what we're looking at before you even come to advocate for your client's bond. And then I think it also will give the attorneys a tool at how to move forward in making bond arguments on behalf of your client.
So I want to start off and talk about what we've accomplished in our first year.
In 2017, we started the implementation with the PSA, which is the Public Safety Assessment. Public Safety Assessment is the Arnold Foundation's tool. It is a risk assessment. It's evidence-based. And we actually started to utilize the Public Safety Assessment prior to the implementation of pretrial services. We realized, as the judge mentioned, that there was a group of individuals that we did need to provide some additional services for, and we realized the need as a court for services beyond just the risk assessment that would determine what someone's bail or bond or release conditions would be. So in 2018, we launched our services to the community. In the first year, we completed 5,589 public safety assessments, and that is on misdemeanor and felony offenders. So everyone that comes in through Cleveland Municipal Court that are in the jurisdiction of Cleveland that have been arrested, they get a public safety assessment. That assessment's goal is to measure their likelihood for new criminal activity during the pretrial phase and their likelihood of failure to appear during the pretrial phase. As a result of that, the judges with Cleveland Municipal Court, they ordered pretrial services to 1,144 misdemeanor defendants. After arraignment, we don't do anything else with the public safety assessments that we've completed on the felony offenders. Obviously, they're bound over to the county, and then they have to continue their cases until they're disposed through Cuyahoga County. In Cleveland Municipal Court, we provided services to 1,144 defendants. Out of that, services that we provided were GPS monitoring, other electronic monitoring device conditions, as well as supervision, which is court supervised release is what we call it. We've provided public safety assessments, our court supervised release, device monitoring, substance abuse testing, community-based referrals. Out of that number, I think it's interesting because we serviced 838 individuals with some type of device monitoring, which is 73% of the people that we released to pretrial services. And although that number seems high, we have to take into consideration that when the city did implement this new bond schedule, that our nonviolent offenders are released with the presumption of innocence on a personal bond, meaning that the people that are primarily being supervised by our pretrial services department are majority violent offenders. We have assaults, we have domestic violence, aggravated menacing cases, and then we have other individuals that do fall into that category that may have missed court or they may have a hold for another jurisdiction, so they are detained as well. But the majority of the individuals that we supervise are violent offenders. There's some victim that is attached to their cases. And we take those things into consideration. And that's why our numbers for our device monitoring, are kind of high in comparison to the total overall number from services that we provide. Our failure to appear rate, as the judge mentioned, is 19%. Prior to the implementation of pretrial services, the failure to appear rate for the city of Cleveland was 42%. after the implementation of pretrial services, those that have been assigned to pretrial, there is a 19% failure to appear rate. And I think that within itself is a good number. But it also, once they're connected to our pretrial services, it gives us an opportunity to re-engage them into the criminal justice system. Whereas they may have missed because of work, or they may have missed because they didn't have transportation, or they may have missed for multiple reasons. But we do have an opportunity to re-engage them in the system. And I think that that number, we haven't measured yet how soon, you know, the amount of time between re-engagement and failure to appear. And I think that that number would be substantial as well. And then lastly, our CSR violations. The violations are really technical violations, generally those that have violated their GPS monitoring device, exclusion zones, those type of things. That percentage is 9% in comparison to everyone that has been placed on court supervised release, meaning that 112 people out of 1,100 have had those type of violations. New criminal activity, because we are measuring new criminal activity as well, that number is 8%, and there are 94 individuals that have picked up a new criminal act while under pretrial supervision. And I think that those numbers alone, it says a lot about the program. It says a lot about the services that the court is trying to provide to the community. I appreciate the comments and how well we're doing. It's trial and error. It's something that's new. We did a lot of research prior to the implementation. We visited courts and we compared some of the services to our community and what our community looks like. But pretrial nationwide is just constantly evolving and constantly changing. So there's some things that we implement that we realize that we can adjust, and there's some things that we offer that we realize that we can better serve not only the court but the defendants in the court as well. And if I can just take a moment, I just talk about some of the services that we do provide. The risk assessment tool that we're talking about, the public safety assessment, it's a tool. And I always explain it that way to the attorneys, the public defenders, the prosecutors. It is a tool. So it is one thing that they can utilize in order to help make the best informed decision. The public safety assessment is an evidence-based tool, meaning that it does not involve an interview with a defendant. It does not take everything into consideration. We do complete a background check. We take that information, and there's metrics that we're plugging it into, and then it populates a number based upon the information that we have gathered. That number is the defendant's likelihood to fail to appear during pretrial and the likelihood of new criminal activity. Understanding that, I think that we have to understand that it does not take everything into consideration. It's evidence-based. So when we talk to attorneys, sometimes they look at the numbers and they don't understand what is a 6 and a 6 or a 5 and a 5. It does not take into consideration your current offense. So if you've never been arrested before and then you come into the court and you have a violent offense, it's not going to take into consideration that current offense. It takes into consideration their history. And I think that's very important. The PSA is the foundation of the services that we provide, okay? So not only do we provide the public safety assessment, the risk assessment for court and arraignment on all of these cases, but then if they are ordered to pretrial services, then that is the basic fundamental of how we make our recommendations as far as conditions of release, how they're going to be released to the community. Pretrial does not make recommendations on bond. We make recommendations on release. So we don't say detain or release. We just say if you release this individual to the community based upon the scores that we have, these are the services that we recommend in order to maintain that they're going to come back to court the best we can and that they're not going to pick up new cases while they're out on bond. So we have a guidelines that we use, guidelines for supervision. And the use of the guidelines is really kind of to take the bias out of the recommendations that we make. They're very strict, straight to the point. They're the same and consistent for every person that comes before our court. We have court reminders, so we are reminding the defendants when they have to appear. We do criminal background checks every 2 weeks on a defendant to determine whether or not they're picking up a new offense while they're out on bond. They have mandatory statutory conditions, which are the conditions that says that you can't leave the state without permission, you're not supposed to use any drugs or alcohol. And then we have supervised release. They either have to report face-to-face or they report by phone, and it's based on their risk levels. So if they score a certain number on their PSA, then that will put them in a bracket of either minimum, medium, or maximum supervision, and that would determine the conditions of their release that they would have to abide by. So in addition to that, we do take into consideration violent offenders. So we have in our guidelines, it's incorporated in there that if it is a violent offense, then they get a bump up in their conditions, so that if they do have victims and there's a risk of victim safety, then we also take that into consideration when we make the recommendations. So that's how we get a lot of the recommendations for GPS devices, home detention. We have services provided for remote breathalyzer and scrim devices. And we take all of those things into consideration as a defendant as a whole. So now we're going beyond the evidence-based, just, new criminal activity, failure to appear. Now we're looking at the defendant as a whole and making recommendations how we can best serve them in the community.
Fantastic. The Thought Leadership Committee of the Bar is really interested in making sure that there's a connection with the bar and the community, and that's the purpose of this hot talk today, is that we want to make sure that our community has an opportunity to learn about the types of things to instill confidence in our legal system. So that's the beginning of the first question, and obviously we can open up the panel to questions from the audience as well. But my first question is, how does and it goes to Judge Earley. It's about confidence in the legal system. How does this program provide to the residents of the city of Cleveland a sense that their judges care, that there are people out there that are looking out for their interests?
So I think this program signifies that we understand that people being detained based on their inability to pay is wrong. That bond decisions need to be made regarding the risk of new criminal activity and your failure to appear rate, not whether or not you could afford to be released. We also, and one of the goals for our pretrial services, again, I'm up here, is to, we're in the process of setting up interviews for people as soon as they're arrested to hook them up with additional services. So, getting people at their most vulnerable and assisting them immediately, as opposed to waiting to determine, we have all of these specialized dockets that we're really, really proud of. And there is a way to get people the services that they need quicker, and we'd like to do that. So that's one of our goals in moving forward. Pretrial, or actually, that's like the next step in our pretrial services model. But the purpose of us, I think, Cleveland taking this lead and making these determinations, because we believe that it is important to the community that the bond decisions be made not on whether or not you can pay, and that people should not be incarcerated because they're poor.
Absolutely. Mm-hmm. So in terms of and again, back to the judge just for a second, because these are the kind of 300-foot level conversations that really are important. There's been so much discussion for so long, and yet you guys in the Cleveland Municipal Court have decided to do something about it, about bond reform and bail reform. How did you work to facilitate the judges themselves, 12 independently elected judges, to come forward and agree that this is a problem and this is a solution? And then secondly, what is the pathway, or is this meant to be a model for other jurisdictions in Cuyahoga County?
So I think my personality is one of collaboration. I think that as the administrative judge, I represent my colleagues because they allow me to. I'm their representative, so I don't have any greater weight or greater authority, or, I've just been given the privilege to represent them. And coming into any program that we're trying to advance, my goal has been to have buy-in. Obviously, before we were judges, we were lawyers. I think a good skill as a lawyer is to be persuasive. And if I cannot persuade my colleagues to do something that is important to the community, that is good for the community, then the problem lies with me. Because this is a good program. This is a, this is what needs to be done. And coming to the, we may disagree with how it needs to be done, but none of us disagree with the fact that people being in jail because they're poor is a good thing. We all realize collectively that that's not who the Cleveland Municipal Court wanted to be. So we had some disagreements about how we made that work, and we sat down and we worked through them. And we did it in a, we didn't drag our feet on it. We sat down and we met continuously until we figured it out, because we all collectively had the end goal in mind. So, kind of what we did was say, this is, as the administrative judge, I was saying, this is what's important to us collectively. How do we get here? And then let's try it this way. And then we worked to tweak it, because I also did not go into the meetings with, it has to be my way and my feelings are going to be hurt. I didn't, I married myself to the concept that at the end of the day, we were going to make a change, but not necessarily to the details. So then we were able to kind of work together to get the collaboration. Is that more difficult? Absolutely. But the result is so much better. And then we were able to build on it because we collectively had in place, this is what we wanted to do. We wanted to make a difference regarding bond reform, and we wanted to do it even if nobody else was doing it. And once we all collectively agreed to that goal, we had different ways of getting there, but we could always go back to the how do we get there today, because it needs to be done today. And again, not everybody, some judges use GPS a lot. Some judges use GPS a little bit. There's variations in that, but the goal is the same. And that's kind of being able to find the common goal. And then to your second question, speaking at the Criminal Justice Council meeting and agreeing to do things like this, I'm very proud of the work that Cleveland Municipal Court and the Pretrial Services Department has done, and that's really important to me. But agreeing to do these things is not necessarily about promoting us, but to kind of say, hey, listen, this works. We could duplicate this. We could, utilize these, what we've done to kind of address additional bond issues, around the county and the Common Pleas Court as well.
Excellent, excellent. And so, in terms of the operational aspects, Director, one of the things that's going to happen this week is the 8th District Conference of all the lawyers, and it's going to be centering around mental health and substance abuse and those types of issues that are so much a part of like the beginnings of a person's relationship in the justice system. So can you explain how you deal with that situation and the procedures and the processes and being able to take a leadership role in the context of adding value to the community, of dealing with really kind of these intransient problems?
One of the things that we're working on currently, and within the next couple months we will have implemented, is our intake unit. Our intake unit, we've already solidified our space in the jail. We're going to be in the booking process. So as soon as an individual is booked into the jail, we can identify what needs-based services they may have. We are screening them for specialized dockets, which also links them to needs-based services. Our specialized dockets, as you know, drug court, human trafficking docket, mental health docket. I have worked with the liaisons for different mental health agencies that are located in the jail, building those relationships and communication avenues for us to get that information to them, so that when they're booked in, just because we identify that they have these needs, we're also linking them to the services that they need while they're in the jail, and hopefully linking them to services when they're released from the jail. Because pretrial they're not convicted, most of the services that we provide now it's on a voluntary basis. So what we do is we link them with agencies, we make referrals to them that are in the community, but it's up to the defendant to actually follow through with the referrals that we make for them currently. But I think the initial thing is going to be just identifying those issues, language issues, different things that we don't identify that can expedite their process and hopefully expedite the services that they receive.
Excellent.
We have a question back here.
You mentioned that you don't charge for GPS. Is it taxed as cost is one of the things I wondered?
No, because, no, that
Okay.
would be, yeah.
And the other thing is, what about the person who's booked in the jail in the middle of the evening? If they get, after the normal working hours and a person gets booked, which happens a lot, do they have to wait till the next morning? I mean, they're going to go to court. Supposedly, they're supposed to go to court the next morning, but if you're going to put in place a screening process before that, it may be they are going to spend a day.
But we're not going to violate someone's rights to be in front of a judge within 48 hours to do a screen. That's why because the law doesn't allow us to do that. So we would not do that. And in addition to that, the person in the what we're setting up is when someone's booked in and when they're doing the conversation that the jail has regarding their mental health status or if they have any medical issues, we're going to be right there at that point.
But I'm saying,
they're going to come right on the docket as they normally would.
Some courts, for example, have access to a judge, a court, right away, even in the evenings, on Saturdays, over the weekends, and something like that. Has there ever thought of doing that?
We have court 6 days a week in Cleveland. So there is a hearing, and I believe that hearings in open court and that are public should be the way to go as opposed to phone calls, personally. I think the law doesn't allow us to do that.
We have a question in the back. Yes.
I can just add one thing as well. We have our staff for pretrial services work 7 days a week. So we have staff that works until 1 a.m. In the morning. We have staff that comes in at 5:30 in the morning. So
with security.
With security, yes. So if you are booked in the jail in the evening, we have staff that will get that information. They get the information done in a timely manner, so there's no delay in the defendant appearing in court, and there's no delay in the judge having the information, the appropriate information that they need for that defendant, because that information will be in the court when the defendant appears in court.
That's what I wanted.
Excellent.
So we currently do that. Yeah, they're working.
I just want to know, I'm sorry I came in towards the end. I just want to know, what's the overall sentiment of the people being helped? Do they feel that this program is overall effective? I know we said the numbers, but I just want to know, what's the feeling of the people actually being helped?
So they don't have to sit in the county jail.
I know that's good news.
So that's significant. And I'm not trying to be flippant, but that's significant. I mean, our jail population in Cleveland has reduced like 50% because we are being able to, if there's a domestic violence situation, for a judge may default to a higher bond because of the nature of the offense. When we're trying to protect one individual, so if we can get GPS monitoring on that person, we can still allow the offender to be released with the understanding that we're to monitor them. And in addition to that, I know this wasn't your question, when we're monitoring that person with pretrial services, we also have a relationship with the Cleveland Police that if, in fact, we get a hit on the exclusion zone, we can send the police out. So we're not minimizing the safety of the victim, and I don't want this talk to indicate that we're doing that when we're doing these GPS monitoring. We are being responsive if there is an issue, but we don't have a number of those issues, and people are being permitted to be released. So that's kind of and people are responding because people are showing up. Even, some people have GPS, but there's some people who do not. The bond reform regarding, in the beginning, when we're doing the presumption of release for nonviolent offenses, that's all the driving under suspensions, the DUIs, all of that. There's a presumption that you're going to come back. And if you don't come back, you may get a warrant. But the presumption is when you get arrested for that, you will come back to court and we give you a personal bond. You don't even come see a judge. It's an automatic personal bond. So you're not held. The order of the court is when you get that citation, even if the officer arrests you, you come downtown, you sign yourself out. It is a personal bond. So that's significant.
So in terms of the...
I'm sorry, did I answer your question?
Yes. I just want to thank y'all for the overall good work that y'all are trying to do.
And following up on that good work, in terms of the personal bond, how does that work in terms of like the discretion of the judge, the assessment itself, and the order by which it occurs? I mean, that really is the heart of what is going on here, is the ability to make that assessment.
So there's two paths. So if it's a nonviolent offense, there is no judicial discretion because collectively as a body of judges, we have agreed that upon arrest for a nonviolent offense, it is a personal bond. So we have collectively gotten together and said that in Cleveland, for an arrest for a nonviolent offense, there is no bond schedule. There is a presumption that you will come back to court, so we're giving you a personal bond. So the judges do not intervene on that because, again, that's that buy-in. We collectively agree that this is what we're going to do. Now, if in fact you don't come to court, then the judge has the discretion to then put a bond on your case because you did not show up. But the presumption is, show up. You're going to show up. So we come into the room saying, you're going to show up, right? And then we want you to show up. That's kind of where that is. The discretion kind of lies in the offenses of violence, where we're setting bonds and we're utilizing the risk assessment. But we're not doing that for the traffic cases. And there's some cases that we probably could capture and do some specialized programs with them. But we're going to do that at arraignment. We're not going to lock someone up to get to that place.
Thank you. And in terms of the operation, to start a department that hasn't existed before, and again, following up on all the conversations that have occurred for over many years here, how did you begin? I mean, what was the the first step to understanding the needs and the process of both the administration of this thing, but also the community?
I think I had a lot of help, like the judge said, because I'm very active in the community. Mm-hmm. I sit on different boards in the community. I participate in a lot of programming in the community. I've always been an advocate for rights of defendants and people. So I think that beyond the court connection, I already had the community connection. So when I started, there was already some structure that was already put in place by the judges. They had a vision. This is what we want to do. I was very familiar with bail reform. I was very familiar with the impact on the community. And it was really just trying to have innovative ideas on how we can bring this to Cleveland. We went to other courts. We've observed other courts and their processes and their services. And then we brought the information back to see how we can fit it to the population that we serve in Cleveland. We actually have our new coordinator. He came from Denver, and he said that they've had pretrial services for 23 years in Denver. He worked at a pretrial service department, and he said we're right on target with what is going on across the country and in other pretrial services departments that have already been established for years. So I think it's just assessing the needs of the people, understanding the needs of the community, understanding the needs of the court, and just trying to kind of bring all of that together.
So
she's being a little bit modest because so she also had to weed out all the applications. She had to do all the first interviews so that the judges could then make a determination. We had to put staff in place. And then when we got staff, she had to train everybody. And then she had to put all the policies in place and get all 12 judges to approve that. So this has been a significant amount of work, and she has done an amazing job for that. I can't say that enough. So she's kind of, being humble, and I appreciate that. But the truth is, this was a lot of work. This was a lot of work. It was a lot of work for us, and we were only doing the small lifting. She was doing the heavy lifting, and it was a lot of work.
And for the, again, for the Bar Association, as lawyers, as judges, the most important thing right now in Cleveland particularly, but all of Cuyahoga County, is confidence in the judicial system, confidence in the system that it works for everybody equally and fairly. And so with this type of program, I mean, do you have a budget for outreach and a budget to tell people the good things that you're doing, or is it just these types of things? On Facebook Live, people hopefully will spread the word and share. But tell me about what kind of outreach into the community you're looking into.
Like budget, oh my God, she was like, that's Judge Earley's buzzword.
Budget, yeah.
So we've kind of just we probably have not done a good job doing outreach, in my opinion. We probably could do better with that. I think we were just so focused on doing it right and getting it right and administering justice that we probably have not done as good a job in outreach. My personality is not always kind of the spotlight type of thing. It's to get the work done and get it done now because it needs to happen now. So we kind of don't do enough of the outreach, but it's primarily because we're so focused on, this needed to happen and it needed to happen immediately. And, we kind of just put our heads down and just, got it done. And we're probably doing a better job. I have one of my public information officers here, so we're trying to start.
Well, there are foundations, and I mean, really,
Right.
there's a lot of information out here to share to get to that place. But I think we have a question in the audience.
Yes, I do. So thank you so much for being here. It's a critically important conversation, and we were delighted to have a chance at the Bar Association to really spotlight the great work that you're doing. We had the good fortune of knowing when Judge Adrian was going through the work and looking at what was happening around the country, as you just said, Stephanie, in seeing what was already happening and taking from real success stories. Two specific questions. Stephanie, could you talk a little bit more? You mentioned that with the failure to appear rate going down to 19%, which is huge improvement. You then mentioned that once somebody gets connected to pretrial services, it then gives a chance to get re-engaged in the system. Can you talk more about what you mean by getting re-engaged with the system?
So when you are assigned to pretrial, part of your conditions would be, or part of our responsibility is to do court date reminders. Generally, if you're missing that appointment or you are in contact with your pretrial officer, that's an opportunity for you to get re-engaged with court, because people will call and they ask questions. Well, why didn't you've made all your appointments, you haven't missed anything, you've appeared in court, what happened? You missed court today. And then it gives them an opportunity. I had work, I didn't have transportation, I didn't have these things. And then it gives them an opportunity to get the information that they need so they can take care of that capias or that failure to appear without just depending on the fact that they think they're going to end up in jail, so they don't come back, because a lot of times that's why people don't come back. But understanding that they are reconnected, then the officer can talk to the judge and let them know, this is the issue, can we get them back on the docket, or whatever the case may be. But it gives them an opportunity to be connected to someone outside of just the courtroom, I think, and they can have that communication, and they can explain to them the process to get back before the judge and what they need to do to take care of that.
Great, thanks. Mm-hmm. And then my second question, Judge Earley, is for you. You were talking about the consistent manner in which when somebody is booked within 48 hours, they get arraigned, and there is a presumption of release. In those instances where release is not happening, I think I heard you say then there is a bond review that is conducted as soon as the assigned judge sits or has a chance to have the defendant appear in front of them. Could you talk a little bit about how often you're seeing a change in decision about bond in that second review that happens with the assigned judge?
So two things. The people who are presumed, the presumption of the personal bond for the traffic cases, I won't see them in arraignment. They walk in arraignment. Hopefully they walk in arraignment. So those would be the traffic cases, the things, the nonviolent offenses. So they should be walking into our arraignment section. So we have two arraignments going on at the same time, and we have an arraignment docket that's only for people who are in jail. So that would be all of the felony cases and then all of the offenses of violence, misdemeanor cases in Cleveland. So at that point, the judge who's hearing the cases will make a determination on bond regarding a defendant. And then when it comes to, and I'll just talk about my docket, I will be able to see that person within, and the judges have a rule when someone's did not post their bond, they're on the very next docket date for us. So if you have another, if they're being arraigned on Tuesday and the judge got a docket Wednesday, they go on that docket. At that point, I will look at the sheet. Sometimes, if it's depending on the risk level, I may say, okay, I'll reduce it. And my determination may also be in terms of the reduction where currently, I have I do the high-risk domestic violence docket, which is where I see most of my cases that need to be adjusted or that are going to be adjusted. The victim and the victim's advocate is present. So then we're having a hearing regarding some information that the judge down in arraignment may not have had. And then I'm able to have a conversation with the person in front of me to say, listen, if you violate, I'm going to have the police come get you, or whatever conversation you need to have. So then I may be willing at that point, because now this person has a connection with me, to then make a determination, say, and I'm going to put you on GPS monitoring. Or they had a hold that was potentially like a county hold that's now cleared up, and we're able to do that. And even if that first appearance I decide, I'm not sure, the next time they come around, pretrial services are like, do you want to release them now? So, and that, and they'll say sometimes, I'll look at the risk level and I'm like, whoa, I see why this judge set the bond. But, there are 12 judges, so I don't have to guess with, did they set the bond because the risk was high or whatever. I have the sheet, so I can see, not necessarily the details, but I can kind of see an overview of what the judge was looking at when they made that determination. And then I may say, you know what, this hold that they have is a traffic hold. I know that no one's going to pick them up on that. I'm going to take a chance and put a GPS on them, and then give them a court date fairly quickly, because now I have more control over that case. So I think it's extremely helpful to the judge who has the case to then be able to evaluate that process. I mean, maybe I'm going to get through my docket, the case with this one individual fairly quickly, because I know there's a high risk, and I'm going to let him out and say, listen, you get a lawyer, we're going to go to trial, immediately, so that we can kind of resolve this issue. So I think that we do make a lot of adjustments, but it's based on the fact that now I have ownership of that case, and I determine how quickly it goes or how that process works.
Any other questions from the audience?
Okay, I'll go one more. Oh, okay, I do have one more since nobody else did. Okay, so my last one is, and I realize it's not your court, but I'm interested if you know what the process is when a felony is moved from the municipal court over to the Court of Common Pleas. And I presume you're handing over all of that pretrial services file over to the Court of Common Pleas. Do you know what happens when the file gets picked up in the Court of Common Pleas, and what, if anything, the Common Pleas Court is doing with the pretrial assessment?
My court administrator is like, don't answer. No, I'm just kidding. She didn't say that. So I'm not exactly sure what's happening with that. I do know that we are having discussions about having a partnership, because that makes sense. Because we're doing, I don't know if you. So we have numbers. We've done like 5,600 risk assessments in a year, and probably 3,500 are for felonies. So we're utilizing the risk assessment. And again, when I started off my presentation, the gap in the risk assessment usage is the pretrial services linkage. So if we were able to have that pretrial services linked with the county, we would have a meaning. The risk assessment would be more meaningful to the court, I believe. So, my hope is that we will partnership with them. We are willing to. I think there just needs to be kind of some more discussion, but we've offered our services to be able to do that. And again, we started with the mindset that that's what we were going to do. So that's why we didn't just, someone may say, and collectively, some of my colleagues, initially, we did say, why are we doing the risk assessments for the felony and nothing's happening? But as you know, sometimes you got to just start, right? And I think that's kind of the, what I took from Judge Adrian. Sometimes you just got to start, and because that's kind of how you lead, right? You got to start, and then when the foundation's in place, then it's easier to move on, and that's kind of what we're doing. And my hope is that movement will be soon.
And we have just time for maybe one more question.
What is the status of bail reform on the county level?
I am Judge Michelle Denise Early of the Cleveland Municipal Court.
But I mean, has anybody, I mean, obviously there's a lot of cases coming from Cleveland Municipal Court, but of course there are other cases coming from all the other municipal courts around the county, and it seems to me that you got a great start. I hear a lot of talk about it.
And I've been presenting this great start we had every chance we can get. So, I mean, we're open to, have people come and replicate that. I can only, yeah, right. And I also think that it's important to, finances are a factor that, people had to consider. I think, when reviewing it, people had to see, and we've been in existence for a year, I think people wanted to see, what are they doing, and is this another one of Cleveland's ideas, and if it's going to work. And I think we needed to, which is why when we present about pretrial services, there is a human aspect of this that is huge, that you can't put a number on. It's significant. But there's also a numerical aspect about it regarding the cost and the savings. And that's why when we do presentations on this, we always have numbers, because numbers are important, because those are what you can use to get your stakeholders on board. We want the human aspect to be the driving force, as it should be, but the numbers are important too.
Well, what we talked about today and what you just mentioned was leadership. And in order for the people of our community, the people of Cuyahoga County as well, to understand that we don't stand still in the judiciary on behalf of the Bar Association. We thank you, both Judge Early and Director Pope. Thank you so very much for your time.